All right. Well, let's. I'm gonna get started. If some people join us a little late, that's fine. We'll try to catch them up. All right. So I'm just gonna give me a second here. I'm gonna make Don. He's gonna co-host. Oh, here's somebody. Do you want Don? Yes. All right, and then Don, you should be able to talk now. Can you hear me, Don?
Yeah, can you hear me?
Okay, great. Can everybody hear Don? Just do your thumb again. Don, okay, good. All right. So I'm with Alpha Omega. We've been doing seminars for the last 25 years on this subject of living trusts, and Don's been doing it with us since we started. So he's probably done 10,000 seminars, maybe more on the subject. He knows it very well. And so we're just going to get right into it. What I would like for everybody to do, just so we don't get stuck or get distracted, is if you do have any questions, there's a chat button at the bottom of your screen, or if you have a phone, there's a way to get to a chat button. When you have a question, just click that chat, and then you'll be able to communicate directly with me. I'll try to answer those questions. If I'm not sure and I think it's relevant for everybody, I might just pause or have Don just answer the question so everybody can hear it. So we may do that throughout the seminar. Usually the questions you have, Don will eventually get to them. He'll answer the question without you having to ask. So write the question down, send me a chat of the question. If I think, oh yeah, he's going to be covering this up in the next 15, 20 minutes, I'll just say he'll get to this in a little bit. If he doesn't, we'll answer it later on. So, but remember, just click the chat, and we'll be able to communicate that way. And just know this, I'm the only one that can see your chats. You can see, everybody can see my chat when I'm communicating to everybody. But when you chat, only I can see your chat, so don't worry about any kind of private information coming my way. I don't expect to ask for that private information, but just be aware that no one else sees it. So that's it. Let's. I guess we can just get started here, Don. Thank you so much for joining us, everyone.
Great. Good evening. My name is Don Swaim, as Corey mentioned, and I'm with Alpha Omega Family Services. And we represent Ameristate Legal Plan, which is one of California's leading providers of revocable living trust. Revocable simply means you can change, alter, or end it at any time. Our attorneys have protected thousands and thousands of families just like yourself all across the state, from Sacramento to San Diego. And our client satisfaction levels have given us our well-deserved A+ rating from the Better Business Bureau, which we're very proud of. If you do choose to have us do a trust for you, we actually end up bringing it right out to your house. That's the final step, which we'll go through in detail later. Also, if we do a living trust for you, in that whole process, you actually become a member of our national legal plan as well, which gives you free legal help on some other issues regarding phone calls or letters that you need making on your behalf by an attorney. Now, this evening, we're going to spend the next 35 minutes or so going through the main difference between a living trust and a simple will. It's a very common question I get. My parents had a simple will. It was no big deal. Things have changed like everything else, especially in California. And we're going to focus on specific reasons why so many people are choosing trust. You keep reading about it, hearing about them, why they are the popular choice, and the advantages they have over simple basic wills. I do want to preface this by saying this: not every human being needs a living trust. I have 4 children. 3 of them have a trust. My youngest does not. What's the differentiating factor? It really has to do with the amount of your assets, and an easy way to figure it out in simple terms is simply, if you own real estate in the state of California, it will trigger a probate. We're going to get into the definition of probate shortly. And you need a trust to protect you from that court proceeding. If you're just renting, have a couple $1,000s in the bank, probably don't need a living trust. So just want to kind of lay that down fundamentally. And I'm very confident when we conclude here in the next 30, 35 minutes, you have a very clear understanding of why trusts are so popular. Magazines, TV, all the time. It's in the news. We'll definitely know that. Now, our seminar is kind of broken down into 4 main sections. The first is the main difference between a trust and a will and why people choose trust over wills. The second thing we're going to cover is more the details of how you set up a trust, and specifically some of the common errors people make when they set up a trust. And having done, we've done over 40,000 as a company. These are very common things that people sometimes have, especially when they have old trusts, they have made errors. These are the common errors that we see. Or at our seminars, when people ask a question about something they want to do, this is a common error that people sometimes think they want to do. And in discussions with us down the line, they'll find out that they really want to go in that direction. And then the third thing we're going to talk about are some medical implications should you become mentally incapacitated. You have a stroke, you have dementia, or something takes place where you're still alive, but mentally you're not functioning properly. We're going to talk about what happens then and the documents needed at that point. My mother had advanced dementia the last year of her life, so I had the legal power to manage her affairs, her medical decisions, handle her money and estate, her house. So that would be something that we'll go into in detail. We include those when we do a trust. The name of those documents, by the way, is a power of attorney for assets and an advanced healthcare directive. So at the end of our meeting, we'll get into more detail about those. And then the fourth and final thing we'll discuss is, should you want to protect your house and family from all the cost and all the bureaucracy of the probate courts and keep your affairs under your control rather than the state of California's control, we'll discuss exactly what are the next steps necessary to get a living trust if you choose us to do it. And again, we've done over 40,000 of these, A+ rating, very proud of that. And so let's get into the first part of our talk this evening, which has to do with the very fundamental reason people get trust. It's the difference between a trust and a will. And the main difference has to do with that word called probate. Now, most of you that live in the state of California have heard of that word. Some of you may even know what it is. Some of you may have even experienced it when your parents died. But probate is simply the court process that will take over, freeze your estate, and they will oversee, control the distribution. Who does the distribution and who gets what? A will is simply a letter to that court. It basically functions as your mouthpiece to the court because you're deceased. And it basically says, dear judge, here's what I want you to do with my house and my wedding ring and all my assets. It does not avoid the judge. Now, about 20% of the people actually die without a will or anything. What happens then is even scarier, and that's the state of California will actually write your will for you, which is a very scary thought. But we're going to assume you at least have a will when you pass away. There are 3 problems with this probate process. Now, every state in America has a probate process. Some states are easier than others. There are 3 states that most of the experts consider to be the worst states to die in because their probates are the worst. And if you're making a wild guess, you're correct. One of them is the state of California. New York and Florida are basically the other 2. States with a lot of population, states with a lot of people over 50, states with a lot of wealth, this is a problem. So what happens if you die? Let's say you have a very simple estate. You're married, first marriage, 2 kids, you want them each to get 50%, you have a valid will. What's the problem? I understand if there's arguing and fighting, you had 5 marriages, but what's the problem on a simple situation? Well, the first problem is time. The average length of time to process a probate under simple circumstances is approximately 1 to 2 years. It can take longer, and I've met hundreds and hundreds of people in my years of doing seminars who have gone through probate that took a lot longer than 2 years. But that means your kids would be taking time off of work, sitting in courtrooms, writing checks to attorneys. It's really an incredible, aggravating situation to put your kids in. So that's one problem, is the time. Okay. Now, the second problem is the cost. You probably guessed this is not free. Attorneys make money. There's court fees, filing fees, appraiser fees. Assuming you have one moderately priced house, let's just say your house is worth, $400,000 or $500,000. The average cost of probate is going to be around 20 grand. Now, the more expensive your estate is, the more your probate would cost. But I'm making a wild guess that each and every one of you out there would much rather give that 20 grand to your children, grandkids, or favorite charity than paying attorneys in the California court system. So the trust will avoid that, and we'll get into details in a minute about that. So beyond time and money, the third problem with probate is the lack of privacy. The whole probate process is public. Anybody's entitled to read your will. Anybody can show up on your court date and contest your will and make a claim. It's all public record, and often people do show up and make claims. And for most people, they find that a little bit intrusive. They have everybody else could know your business. Your neighbor knows exactly what you own and who you're giving what to. Most people aren't really comfortable with that. And in addition, there's some other benefits of a trust, which I'll get into, which have to do with distribution choices, delaying distribution, setting college scholarship funds up for grandkids, delaying distribution for kids that can't handle money. We'll get into that in a little bit later in our seminar. So those are the main problems with probate. Now let's contrast it, that same situation, and they had a revocable living trust. The time it takes to process an estate in a living trust is literally months. Now, when my mother passed away 2 years ago, she had a trust, said that I get half the estate and my sister gets half. We actually liquidated all the assets within about 20 days, with the exception of the house, put the house up for sale, but the house took about a month and a half to sell. So we got all the assets within 20 days. The money from the house came down to us a couple months later. So it's very, very quick and precise. No one's sitting in courtrooms. No one's taking time off work, getting babysitters for kids. None of that goes on. So that's one huge, huge significant benefit. And quite frankly, it's probably a benefit that is so important, it's worth getting a trust just for that benefit. But it also has to do with money. As I mentioned, the cost of a probate under simple circumstances, about 20 grand. You're a blended family. Think about this. You have 2 kids from her first marriage. Your wife has 3. You guys pass away, car accident or something. Picture all your kids in a courtroom fighting for percentages of your estate. What was your net worth before you got married? What was your wife's? You can imagine the arguing and fighting. Anyway, this avoids all that nonsense. Now, no cost of the probate process in a trust, because there is no probate. Nobody goes to court. It's kind of like, hey, what's it cost to go to UCLA? It really doesn't matter. You're not going to UCLA, okay? There's no cost, rich or poor, there's no probate. So you save the time and the aggravation, all that. And a trust is private. I mentioned earlier, wills are public, trusts are completely private. Nobody can see the trust unless you're a beneficiary. It's nobody else's business, quite frankly. I mean, if I'm giving everything to my kids, it's really my cousin, my neighbors, it's really none of their business. Trust or private. And again, you have tremendous choices of flexibility. In about 10 minutes, I'm going to get into how you set up a trust. And one of the key things we're going to talk about is beneficiaries and distribution choices. So those are the fundamental reasons people get trust. Avoidance of probate, have your affairs private, and make sure that the hard-earned assets that you have accumulated in your lifetime all go to your family and charities, not to attorneys in the courts. Okay? Now, how do you set up a trust? Now, there are some key people in the trust before we talk about assets. The key person is the person that sets that up, and that's going to be you. And then you're going to appoint yourself to be the trustee and run the trust. Now, again, as I mentioned earlier, you are in complete control of the assets in the trust as long as you're alive. That's why it's called a revocable living trust, while you're alive. If you decide to sell everything and die broke, you can do it, okay? So you're in complete control of your assets, move out of state, do whatever you want to do. You're called the trustee. Now, I'm married, so my trust is called the Don and Susan Swaim Trust. Don and Susan Swaim are the trustees. So we both are in control of that trust. If I die first, she'll run everything. If she dies first, I'll run everything. It's a little bit like we have a restaurant called Don and Sue's Diner. We're the owner, presidents, we run the restaurant. I die, what happens? My wife just continues to run the Don and Susan Diner. Same concept, she'll continue to run the Don and Susan Swaim Trust. My dad actually predeceased my mother 11 years ago. So my mother, in the remaining 9 years before she got dementia, she ran the Charles and Marilyn Swaim Trust by herself. Now they're both deceased. They appointed me to be the successor trustee. I then took over and ran the trust according to my parents' instructions. And that leads us to the next key person in the trust. It's that person in the number 2 slot. They're called the successor trustee. Kind of think of them as a vice president. President dies, vice president takes over. Now you're going to pick someone to succeed the trustees, whether you're single or married. When the trustees are gone, the trust is frozen, cannot be altered or changed. They simply have the power to execute your instructions. So let's go back to my mother. Her trust said, liquidate all assets, give half to your sister and keep half. That's what I did. Okay, so you're going to pick anybody over 18. Now, I would say that 90% of all the people we've done trusts for choose one of their kids to be the successor trustee. Okay, I chose my son to be the successor trustee, but you can choose anybody, your neighbor, your nephew, the mailman, anybody over 18. Whoever you choose, you want an alternate. Why? Because that person you choose could predecease you. They could get cancer. They could be in a car accident. They could be in the car with you. So for instance, if my mom and dad, I was in the car with them and we all died in an accident, then my sister was the alternate and she would have taken over and distributed the assets. So you always need a backup. Now, one other thing that I get asked all the time about successor trustees. Well, listen, Don, I'm in my second marriage. I want one of my kids to be the successor trustee, but my wife really wants one of her kids from her first marriage to be the trustee. We got a problem. Well, you do have the ability to pick two successors, make them co-successors, one of your kids, one of your wife's kids, and together they both have to sign documents to release and liquidate the assets. So that's a very common thing in a blended family, but that doesn't always be the case, but anybody over 18 can be the successor trustee. Now, as long as you're alive, you can change that successor trustee. So let's say I pick my son Cliff to be my successor trustee, and 5 years down the road, we have a falling out, he has a drug problem, I can change it. Just like if I had a restaurant and I don't like the cook anymore, or he's not doing a good job, I can change the cook. You can change your successor as long as you're alive and mentally competent. The minute you die or lose mental competency, then the trust goes from being revocable, which means changeable, to irrevocable, which means non-changeable. Okay, so successor trustee is a key person. Last thing about successor trustees, I get people occasionally say, Don, I have no kids. I have one kid, but we have no relationship. Or I got one kid, he's got a big drug problem. I don't have anybody. I have no other relatives and friends. I just moved here from Canada or whatever. If you do not have a successor trustee who you have confidence in, it's not a super difficult thing to do. You don't need to have, your kid doesn't need to be a college graduate to be a successor trustee. It's a simple thing to do. And they can call, by the way, us and ask questions and we'll give them some guidance. But if you don't have anybody, and that may be the reason you've never done a trust, you don't have anybody to run it when you're gone. You can pick a bank or financial institution. There's a lot of people who would do that and execute the trust and pass it out to your charities or nephews or whatever. And we can give you some direction in that regards as well. I would say maybe 5% of our clients have a person be the successor trustee who's not a relative for a variety of reasons. So that is an option. At any time, you can change it. Okay, so you have the trustee who runs the trust while you're alive. That's you. You have the successor trustee who executes your plan upon your death. And then the final people in the trust are called beneficiaries. They're the ones who inherit the assets. Now, people ask me all the time, Don, can the successor trustee be a beneficiary? And as I mentioned, yes, most of the time they are. I'm not going to pick my son to run the trust and then disinherit him, right? So they usually are, but again, they don't have to be. But the beneficiaries receive the assets. Now, here are some additional benefits to a trust when it comes to distribution. You have a lot more choices and flexibility of how and when to distribute the assets. So let me give you a couple of common examples. Don, I got a son, he's 25, but he's kind of irresponsible right now. He drinks a little too much. If I die tomorrow, I've got a house paid off and other assets, and he's going to inherit $500,000. Well, he's going to blow that money really fast. Is there something I can do to kind of protect the estate? And the answer is yes. You could set up the trust that upon your death, he gets half of the estate and he gets half of it when he's 30, or he gets 1/10 of it now and he gets 1/10 of it when he's 30 and he gets another 10th when he's 35. You can set it up under any distribution you kind of want, Sometimes people say, Don, I have a grandson. I'd like to leave money to him, but he's 10 years old. If I have a will, he's going to get the money at 18 and go blow it on motorcycles and boats or something. You could set up the trust for that 10-year-old grandson and have that money set aside and actually designate It can only be used for college. It's not to be used to buy motorcycles or cars. It's used to go toward college expenses. So you can not only spread the distribution out, it does not have to liquidate 100% upon death. It could be doled out over the next 30, 40, 50 years. You can actually designate specific things that that money can be used for. So a lot more choices and flexibility, and very, very critical. And again, when you talk about beneficiaries and distribution, let's go back to the blended family, which about half of our clients are in second marriages due to the divorce rate and death. Let's say I'm in a blended family. I die, I have 2 kids. And then my wife and I have a will, been married for 10, 15, 20 years. I die, it now goes to my wife. She lives another 5 years and dies. Guess where the estate goes? To her kids. My kids don't get anything. So another reason to get a trust is when it comes to this distribution issue, you can set the trust up so that upon your death, your half of the estate is in essence frozen. And that way, when your wife passes away, you make sure your kids at least end up with part of your estate. Otherwise, quite frankly, whoever dies first, their kids are kind of out of luck and they're at the mercy of the new wife or the new husband to get anything. And often, years and years after you're gone, wife remarries and your kids don't end up with anything with a simple will. So blended families, it is critical to make sure you have this stuff set out. I believe it's critical even if you're on a first marriage and have 1 kid, because I don't want my 1 kid to have to pay money and sit in a courtroom to get my house. But it's really critical if you're in a blended family situation, okay? You may have a disabled kid. Trust can be set up to protect them and have those assets for their benefit years and years and years after you're gone. You can't give them the money. A, they're not mentally competent to manage the money. B, it could affect their benefits by inheriting assets. So a lot of different reasons why people do this, okay? Now, we've talked about the reason to set up a trust, avoid probate. We've talked about the people that run the trust. You run it while you're alive. You designate someone to take over and carry out your instructions upon death, the successor trustee, and then you've designated who gets what. Charities too, often people give 5-10% of their estate to a charity upon your death. Pet shelter, church, American Cancer Society, whatever. Those are all good, worthwhile things to do. Now, the trust, once it's set up, it's good the rest of your life. Okay, people say, is there any ongoing cost to keep my trust in effect? No. The key thing is with the trust is once it's established, if you were to sell your house, buy another house, for instance, which I did in the last year, you simply buy the new house in the name of the trust, okay? You buy that new house in the name of the trust, so the trust owns the house, because all the assets that my trust own are protected by the trust and avoid probate, okay? And the house is the biggest one that's out there, because you don't have a beneficiary on your house, right? You might have a beneficiary on your life insurance policy or your CD. That won't go to probate because you got a beneficiary. Don't have one on your house. Don't have one on your wedding ring, your furniture. So all the house and the contents of the house, collections, so forth, need to be in that trust. It's called funding the trust. And we'll get into more detail with you on that in setting up your trust, because everybody has different assets, different questions, different desires. That's one thing I've learned over the years. Every house has a floor, walls, and a roof. But inside, they're all different, right? Different layout, different furniture. The trust has certain elements that everybody has, but within those elements, everybody has different desires of distribution and the way they want to set it up, and their life has had a different experience and issues that need to be addressed in the trust. So they all have their uniqueness inside them, okay? Now, the last document I want to talk about, and the last area that's featured in our trust, are the 2 documents that protect you in case you lose capacity due to dementia, car accident, stroke, whatever. One is a power of attorney to manage your assets should you lose mental capacity. And the other one is called an advanced healthcare directive. So you're going to appoint someone to make all those decisions about your health and manage your money should you become mentally incapacitated. Now, I happen to be married, as I mentioned earlier. Can anybody make a wild guess who I chose to be my power of attorney should I get sick or have a mental issue? My wife, okay? She would kill me if I didn't choose her, but she's my #1 power of attorney. But it is possible we could have an accident, I die, or she dies, and I'm mentally incapacitated, but I survive. Who takes over? My wife can't do it. In that case, I have an alternate. Just like I have an alternate successor trustee, I have an alternate power of attorney, which happens to be my son. Okay, so you need a backup. Now, here's a common situation, and again, pertaining particularly to blended families. So I appoint my new wife to be my power of attorney. She passes away before me, so I appoint my son or daughter to be the alternate. My wife appoints me to be her primary, but if I'm not there to do it because I predeceased her, she picks one of her kids to be her alternate. In other words, typically in a blended family, you have different alternates. Now, by the way, I don't have to pick my new wife of 10 years to be my power of attorney. I could pick my son who's 40 years old. I want him to do it instead of my wife of 10 years. My cousin's a doctor. I want him to do it. You can pick anybody over 18. And the key issue here is, someone that you feel confident about and you trust, and then somebody that's over the age of 18. It's particularly advantageous to have someone close. I mean, if I had two kids and one lived by my house and one lived in Florida, and I really had equal confidence in either one of them, I personally would pick the one that lives by me, just because it's a little bit easier to go to the local bank, and if I'm in the hospital, they can go see me. But legally, they don't have to be. They could be living in China, for that matter. They could be living anywhere. Okay, so those are some of the common issues, and the common mistakes in regards to the powers of attorney is people don't have an alternate. They pick one person, but no alternate, and that person happens to predecease them or be in the car with them. So you always want alternates, or they pick somebody who's, maybe in the military and they're stationed over in the Middle East, and you're now in the hospital. Well, they're not really in a good position to really manage your care on a daily basis. So you always want to kind of look and reevaluate who you've chosen to make sure that their lifestyle and the geographics and all that fit in a place where they still can do it without a lot of stress in their lives. You don't want to add stress to your kids' lives. This is all about saving stress, reducing stress, or eliminating it entirely. I mean, I miss my mom, I miss my dad, but I didn't have to go to court and pay a bunch of money to California to get their estate. When they were sick, I didn't have to go to court and get the power to take care of my parents. I just could immediately take care of them, and had the power to do that without asking the courts. And by the way, if you don't have those medical documents, then your kids would actually have to pay money and go to court and ask California to appoint them to take care of you. If California chose them to do that, they would now have to post a bond to take care of you, which to me, it's a crazy thought that I have to go into a courtroom and pay money to the courts and ask a judge, can I take care of my mom? And then he gives me the power, and I got to go and post a bond to take care of my mom. That whole thing sounds completely ludicrous, which I believe it is. This avoids all the nonsense. One of the common mistakes people say is, my mom died and there was no problems. Well, when did she die? 1975. Okay, where did she die? Kansas. Well, 1975 Kansas, there probably wasn't a big probate problem. It's probably real simple, but we're talking about 2021 California. It's a different world. The issues are bigger. The courts are jammed. And you've worked very hard to get whatever you have. Nobody, probably out there won the lottery. Protect it, but more important than that, keep them out of a courtroom. So those are some of the basics. Now, if you want to get started or find out more about how to get started, I'm going to turn it back over to Corey, but it is a very, very simple process. As I mentioned, done over 40,000 of these A+ rating from the top of the state to the bottom of the state, and from San Luis Obispo to Mammoth, everywhere, and very, very high recommendation factor of people who have our trust. They turn over their relatives and friends to us and recommend us, which means they're happy and satisfied. So Corey will go with the next steps about how to get started and what you need to do to take the next steps. And if you need a couple more questions answered specifically, Corey will be happy to answer those as well. So I'm going to turn it back over to Corey. I appreciate your time, and you guys have a great rest of the evening. Thank you.
Great. Thanks, Don. Stay on with us, Don, too. I'm just going to, I think what I might do is just, if anybody has any questions that I can answer or Don can answer, just raise your hand. I'll ask you to unmute yourself, and then you can ask the question that way. And if not, I will, if there's no questions, then I can tell you the next steps if you're interested in moving forward with getting this. Anybody have questions? Horace had a question that I answered, and I think I answered it pretty good, Don, but his question had to do with, if I don't have anything but accounts with beneficiaries, no real estate, what's the advantage of having a trust? And maybe you could touch on that a little bit, Don.
Well, it's possible you don't need a trust. People without real estate and just with bank accounts with beneficiaries, sometimes they still get a trust, and for the following reasons. One, if they have a distribution issue, for instance, I have a $100,000 CD and I'm leaving it to my daughter, but I don't really want her to get a check for 100 grand because she's going to blow it in 90 days. So therefore, I might want that CD to be in the trust and use the trust as a mechanism to delay the distribution and give it out over time. That's often one reason. Make sure you have a backup beneficiary. A common mistake people have is they have a beneficiary on their CD bank account, but they don't have a backup. That person dies, that asset goes into probate now because there's no backup. Or within the trust, you have a backup for every asset you have. So it's a safeguard in that regards. But if you just have one kid, there's no distribution issue at all. You have no problem. Don't need to delay distribution. Then you might not need a trust. But we'll go through that with you in detail. There's some other follow-up questions we could ask you, but you may or may not need one.
Great. Yeah, that's exactly what I texted Horace too, basically the same scenarios. So hopefully that answers your question, Horace. Rosindo has a question. What does funding the trust mean? So funding the trust, Rosindo, is making sure that probatable assets get put into the trust name. So Don was talking about that earlier. Your deed is your house is probatable. So in order for it to avoid probate, you have to retitle that asset. So right now, if you're just single and it's just your name on the deed, it may say Rosindo Meha, and we would basically just take it out of your name and put it into the Meha family trust. That's funding the trust.
And we help you with that process.
Right. Yeah, we do that for you. We're gonna hold your hand throughout the whole process of getting this trust done. The way it works is we start the process right now. We start the process today, typically. And what we would do is just take some basic information, your name, your phone number, your address, that gets things in motion. That we would then get that into AmeriState. Don mentioned the company that will be doing this. They've done 40,000 trusts over the last 25 years. They will then take over and they will assign you an attorney. They will prepare you for that attorney consultation. We get the process started. What we do is we're experts in presenting the information, educating people, and then they're the experts in actually preparing the documents, setting you up with the attorney, getting the documents created, and then we get it. Then we have a notary that comes out to your house to deliver the documents, and at that time, everything is complete. So that's how the process basically works in a nutshell. We'd be happy to serve you. Our fee to do this, normally it's $1,795. We are offering a $300 discount through our seminar. So it's $1,495 for the trust. That includes everything, all your powers of attorney that Don mentioned, all the documents, the attorney consultation, the notary charges, the delivery fees, everything we do is included in that fee. There is one additional fee, the funding part of the process that we were just talking about. Everybody's different. Some people have no houses. Some people have one house. Most people have one house. Some people have 2, 3 houses. So the base fee is the $1,495. There is an additional $200 fee per piece of real estate that we have to take out of your name and put it into the trust name. There's no other hidden fees. That's the fees. It's all it's one package, one program, and like Don said, we are experts in this. We do this. We do a great job. We have an A+ rating with the Better Business Bureau, and we would love to serve you in this day and age. It's even more so now with COVID. It's important to plan properly, and that's what we do. We make it easy for people to do that. So if you're interested in moving forward, it's real simple. All you have to do is reply back in a chat. And remember, that chat goes directly to me. No one else sees that. Just reply back in a chat with your name and your phone number. That will indicate to me that you are interested and you want to talk further. And then what I'll do is I will call you. Don may call you, or Gene Adams. He's on the call with us as well. He will call you, and we can get the initial application. It takes 5-10 more minutes, and we'll call you tonight still and get that done for you. So we'd love to serve you. if you're interested, I'm just going to leave this meeting open. If you need to think about it for a second, I'll leave the meeting open. Again, just reply. You just click that chat button. Click the chat button. It goes directly to me with your name and phone number, and I will get back to you, or someone from my office like Gene or Don, who presented the seminar. We'll get back to you, and we will get that process started. But we appreciate you taking out the time out to watch our seminar tonight. Hopefully we can serve you. We always say this at our seminars: if we don't do this for you, someone needs to do it for you. So if it's not us, get it done. But we do this. We are experts at this, and we would love to serve you if you'd let us. So just chat to us. Put that chat on. I'm gonna stop my video so you don't have to see my face. But you can just chat to us, and we'll get that process started. It's real simple. So thanks so much, everybody, for watching. I'm gonna leave this meeting on. Just chat us if you're interested. Thank you very much.